society, as is the case in Canada, requires that we ensure a balance between the imperatives of national security and other imperatives that could justify maintaining secrecy and the transparency that is inherent in our system. The right of the public to know could take various routes to make public certain facts without undermining national security or other interests that could justify sealing of information. So some facts could be made public because they may be explaining why national security and other imperatives are concerned by the documents or information concerned. Thank you, Madam Commissioner. Thank you, Professor Trudeau. I have two questions for you, questions of clarification. This afternoon, there will be questions put to you and to your co-panelists. You talked about the use of black boxes. This is something that we've seen in legal documents. Jurists are aware of this. But for the public, what do you mean by this concept of black box? Actually, the public and the media, when exceptions to the principle of transparency are invoked, so the different types of exceptions, they find themselves in a situation where they know nothing about what it's all about, what the subject matter is, the reasons for which information cannot be disclosed. Therefore, it gives the impression that we need to believe people. So there's some kind of mystery. So you can't access or know the information because you cannot have access to the information. So it's not very satisfactory as an answer. This is the type of black box effect that could undermine public trust in institutions and in different processes, including legal processes, where we could find such situations. In other words, the black box effect is an effect where the public finds itself in ignorance. So to offset this black box effect, we should be able to provide the public with clarifications on the reasons why we cannot disclose everything contained in the black box. We need to find a mechanism and practice such a mechanism through which the public could have access to information that, while protecting the interest that need to be protected, allow at least certifying that we are indeed in a situation where the exception to the principle of transparency applies. So when there's a black box effect, the public could be tempted to think that the exception is being used or invoked without true conviction that the exception should apply. For example, the reason may be to hide information or to withdraw information that may be embarrassing without undermining the life or security of an individual or of the state. So there could be temptation, or the public could feel that a public decision maker could be highly tempted to invoke the exception, particularly if the exception is very absolute, to hide situations or facts that should not be part of that exception. For example, with the intention to hide any misbehavior by a decision maker or an organization. Question, if I understand you, when we find ourselves in a scenario where disclosure is not possible, the Communication Act that should be completed is to explain the reasons why the black box exists and why the public cannot have access to that. Answer, absolutely. In other words, when we find ourselves with a black box situation We need a mechanism that explains to the public why the information should remain in the black box, what the reasons are. And in cases where we can't go further with disclosure without compromising the very protection of individuals and security, then we need to rely on an independent third party that is impartial, who can come and tell the public, I have looked into what is contained in the black box, and I have realized that, indeed, the exceptions provided for by law and which allow that some information not be disclosed should remain in the black box, and those reasons are justified. Of course, you may say that all this is based on the fact that in a democratic society, the judicial system enjoys some trust and confidentiality. I know that we are going through a period where some countries do not have this vision of a judicial system. But I still believe that in Canada, the judicial system ensures that we have judges that are independent, impartial, and have the necessary stringency to reassure the public when it comes to the existence and reality of reasons for which we must not disclose some information to the public. Question. Professor West had a question.
I totally agree that in a democracy, the just trust us response is not sufficient ever. It's not a reasonable justification for a limit on the public's right to know. However, I would say that there are very rare and particular instances, I'm thinking here of even the existence of a human source, where saying the justification for not revealing this information is because it comes from a human source could potentially reveal the identity of a human source in certain circumstances. And in that case, that's where you need that independent third party who they themselves may not even be able to explain the justifiable limit, but to verify that limit for the public.
Thank you. I will leave the podium to my colleague, Erin Dan.
Prior to that, j'ai une question pour...
Before that, I have a question for Professor Trudel. Of course, since I've been a judge myself for almost 10 years, this matter of the public trust is one that I consider very important. In the context of a commission of inquiry like this one, there are two issues that I would like you to consider. A commission of inquiry that is independent, presided over by an acting judge, and which will have access to information that may be otherwise protected for national security reasons. You have referred to mechanisms that should be used to engender public trust. Could you please tell us more about what you consider to be mechanisms that could be used by such a commission of inquiry to reassure the public and to instill the necessary trust? Answer. Fundamentally, I think we are talking about mechanisms that could be used by the judge to explain to the public why, in certain situations, with certain information, some information cannot be made public. I don't believe that there's a standard mechanism as such. We find ourselves in a situation. Well, first of all, let's make sure that we minimize as much as possible situations where information will be sealed, and when it's not possible, the reasons should be explained. Reasons explaining why it's not possible. The mechanism that come to mind are the usual mechanisms used in judicial decisions. For example, the judge explains the reasons why they have decided why a document should remain confidential or why certain documents should be redacted, or the reasons justifying such a decision. That seems to be the most useful mechanism. Of course, mechanisms could take different forms. In the context of a commission of inquiry, the commissioner, I believe, has the capacity to exercise this decision-making authority. Thank you very much. Thank you.
Building then on Professor Trudel's very helpful comments, we turn now to Michael Nesbitt, who will speak to us continue to speak to us on balancing secrecy and confidentiality with democratic transparency. Professor Nesbitt is an associate professor of law at the University of Calgary Faculty of Law, where he teaches, researches, and practices in the areas of national security and anti-terrorism law, criminal law, and the laws of evidence. Professor Nesbitt worked as a lawyer and diplomat for Global Affairs Canada and as a lawyer for Canada's Department of Justice. Professor Nesbitt's SJD dissertation, helpfully for us today, concerned commissions of inquiry and their methods, procedures, and receipt of evidence. He is a senior research affiliate with the Canadian Network for Research on Terrorism, Security, and Society. Professor Nesbitt.
Thank you so much. It's a pleasure to be here and an honor to be here. To reiterate, the task, as I understood it anyways, that I've been given is to offer some high-level contextual background on the importance of balancing secrecy and confidentiality with democratic transparency and what factors are at play, and perhaps end a little bit with how we might think about going about that task. I will, however, start with a caveat, and that caveat is that the Commission is not alone in its broad task, nor is it alone in the task of searching for the right balance between national security confidentiality and democratic transparency. Indeed, there are many beyond this inquiry that reside within and outside government who perform oversight, review, and accountability roles in the national security context, all of whom have to balance the need for secrecy and confidentiality with democratic transparency to greater or lesser degrees, all of whom will push to release information to the public, while also recognizing the importance of keeping other information secret, and all of whom can provide lessons for the Commission and for the public on how this task is accomplished. Just quickly review the main such bodies so they're on the table and known to everyone. We have NSIRA, the National Security Intelligence Review Agency. We have NCCOP, the National Security Intelligence Committee of Parliamentarians. We have an Intelligence Commissioner within government. We have other officers like the PBO and the Ethics Commissioner. And I'm going to mention a couple others that I think are really important. The first is well known to the Commissioner and Commission Council, and that's the courts. And the other one is the media, including through how they choose to handle access to information requests, whistleblower information, and so on. So, with that said, how is this balancing navigated between what I will call democratic accountability and transparency on the one hand, and state secrecy and confidentiality on the other? The answer, and perhaps it's too professorial to say, but it's complicated. And so I think what we need to do is start with the big picture principles, as we often do in law and national security, and then dig down into how those can be applied on a case-by-case basis. Firstly, it is then important to remember, as Professor West just mentioned, the very good reasons why governments maintain secrecy and confidentiality in a number of cases, including to protect lives, or, contrary to what some may think, even to protect the rule of law. For example, by ensuring privacy, where privacy laws apply, or the safety of individuals within Canada is maintained. As the Arar inquiry said, Commission of Inquiry reviews concerned the most intrusive state powers of the state, including electronic surveillance, information collection and exchange with domestic and foreign security, intelligence and law enforcement agencies, and so on. Let me add to that so on. Secrecy is needed for reasons primarily related to the protection of sources' lives and well-being, and that includes both human sources and those working undercover for security agencies. It's needed to protect techniques, methods of information collection, especially from those looking to overcome those methods of information collection. It's needed to protect employee identities in some case, particularly, as I said, those working undercover, as well as some internal procedures. It's needed to protect information received from foreign partners, and in so doing, protect these foreign relationships. For Canada, this shouldn't be diminished. We have a Five Eyes partnership, which many will have heard of, and Canada is, as is well known, a net importer of intelligence, meaning these relationships are extraordinarily important to us, and the flow of information and the ability for Canada to maintain its secrecy and relationship is extraordinarily important to us. We also, I would add, must protect the intensity of investigations in some cases that are ongoing, or how, when, and why investigations in the past may have failed. All good information for those looking to overcome the investigations performed by Canadian security agencies. I'll add that outside of the national security classification claims, there's one thing I did want to bring up, which is just that we may also see cabinet confidences and references to solicitor-client privilege claims that append to, that these are not national security claims, of course, but they can append to national security information and documents, and thus perform the same function in many ways. They may hinder the Commission's access to information or the public access to information. That is the ability for the Commission to make such information public. In that regard, we must also note that these are two areas of confidentiality that I understand the Commission may never see. The Commission's terms of reference allow for the release only of those cabinet confidences that were provided to the independent special rapporteur on foreign interference in relation to the preparation of his report. And while there is a process for negotiating solicitor-client privilege documents, those will not, as I understand it, be afforded as of right. These are, of course, important possible limitations to the information, both that might, one supposes, be made available to the Commission, but also to the public. There are also legal requirements related to all of the above protections, and I will leave my discussion at that and allow Professor West to provide those details with which we in Canada have entrenched the protections of sources, methods, and information acquired from foreign partners that I've just discussed. So bearing in mind what I believe to be these very good reasons to protect national security information and maintain secrecy, we must simultaneously remember that the purpose of national security in Canada at a broad level is to keep all of us safe and help protect our lives, our livelihood, our way of life, and our democracy. In short, in a democratic nation like Canada, the task of national security operators is, at the broadest level, to work for all of us. This means, as a necessary corollary, that national security powers and actions must be valid expressions of the will of us, the people. As a result, as Professor Kent Roach said in reviewing the Arar inquiry, there is a real need for reviewers to make public as much information as is consistent with genuine national security concerns about protecting sources, methods, and relations with foreign governments. This, I think, brings to the fore the essence of the reciprocal and admittedly caveated relationship between protecting the security of a democratic nation on the one hand, and promoting through transparency the sort of democratic accountability and values that ensures power is maintained in the hands of the people on the other. Transparency begets democratic national security, and democratic national security includes, as a sine qua non, transparency and accountability, while allowing, as a matter of responsibility, what Professor Craig Forsees has called, quote, principled secrecy. To put it in more concrete terms, there is the imperative on the one hand to keep people safe, and likewise to keep information secret that keeps people safe. And there is, on the other hand, an imperative to push to share as much information as is possible to ensure transparency and through it, democratic accountability. In practice, I truly believe that Canadian agencies and their employees well recognize this reciprocal relationship, this tension, including the imperative for transparency and accountability. Indeed, it's frankly my suspicion that they are more acutely aware of the issue than most. But looking at past inquiries and the reports of some of our review bodies, as well as court cases in the national security arena, it must also be said that there's a tendency as a matter of practice for the balance between secrecy and transparency to skew, at least in the first instances, or where the disputes first arise, towards secrecy. Let us look at national security at a fundamental level to see why. By this, I mean a simple day-to-day practice level. Most laws and institutional mores in national security agencies will rightfully tell security operatives their jobs are important. It's a job of manager. And their jobs are, in part, to keep state secrets. Indeed, these employees will be made well aware that these laws exist, including in our Security of Information Act, and that these laws will criminalize the unlawful release of state secrets by those bound to secrecy. At the same time, rarely if ever, is there punishment, at least at an individual level, for failing to be fully transparent. In short, we need a balance of transparency and secrecy, yet most laws and day-to-day practices, the understandable cultures in national security, operate to pressure the prioritization of secrecy. The same is bluntly true even when it comes to national security redactions that happen every day within government, that being those reviews that look to Section 38 of the Canada Evidence Act, which Professor West will discuss more later, to determine if information, if released, would be injurious to national defense, national security, or international relations. In the context of something that I think is more broadly understood than some of what we might discuss today, that is access to information requests, or inquiry requests, should it come to that, the following dynamic might often hold. Release too much information as an employee, and you will receive a reprimand on the job at best, or a criminal charge at worst. Release too little information, and the requesting party will fight the government over it for what might be, frankly, years, to the point that the original reviewer and classifier of the information may have long since moved on. I'm sure that if there's any media in the room, and I know there is, they will be well aware of this dynamic. In fact, once a review is complete and the redactions are suggested, it tends to be the case that someone else will review the first reviewer's work. The incentive in each case will be to classify more information, not challenge the classification of colleagues, though that surely happens. The more a document is reviewed before release, in short, the more important it is, the more redactions one might expect to see. The result, almost inevitably, and to my mind through no real fault of any individual, is a system that will necessarily overclassify. And this is a problem we have seen mentioned in numerous court cases and government's reports, but perhaps most forcefully for our purposes by the Arar inquiry. Indeed, don't take my word for it. Take the word of eminent Justice O'Connor, commissioner of the 2004 to 2006 Arar inquiry. He said, and I think it bears repeating, it is perhaps understandable that initially officials chose to err on the side of caution in making national security claims. However, In time, the implications of that overclaiming for the inquiry became clear. I raised this issue to highlight the fact that overclaiming exacerbates the transparency and procedural fairness problems that inevitably accompany any proceeding that cannot be fully open because of, I'll put my own words here, legitimate national security concerns. It also promotes public suspicion and cynicism, as Professor Trudell discussed, about legitimate claims by the government of national security confidentiality. It is very important that, at the outset of proceedings of this kind, every possible effort be made to avoid overclaiming. Justice O'Connor then went on to say, I am raising the issue of the government's overly broad national security claims in the hopes that the experience in this inquiry may provide some guidance for other proceedings. In legal and administrative proceedings where the government makes national security claims over some information, the single most important factor in trying to ensure public accountability and fairness is for the government to limit, from the outset, the breadth of those claims to what is truly necessary. Litigating questionable national security claims is in nobody's interest. Although government agencies may be tempted to make such claims, to shield certain information from public scrutiny and avoid potential embarrassment, that temptation should always be resisted. For this reason, I'm going to end with a less theoretical justification for the need for transparency and instead offer some very practical ones. At a most basic level, national security review can take place with a view to propriety. That is, did the actors do the right thing? Did they obey the law? And with respect to efficacy and efficiency. That is, are the laws and practices in place for the studied actors to do their jobs effectively and efficiently? In terms of propriety review, transparency and accountability measures can identify and correct wrongdoing, whether intentional or accidental, which includes the hiding of mistakes. Such wrongdoing might even be what we call, in quotes, noble cause, which is exactly what the MacDonald Commission found in looking into RCMP activities in the aftermath of the 1970 October crisis. Do keep in mind that propriety review is not to be dismissed in the context of Canadian inquiries. Bluntly put, Canada has a history of wrongdoing, including and perhaps especially that which has come to light as the result of past commissions of inquiry. In terms of the efficacy and efficiency review, this is the other side of it, and the benefits fed by transparency, again, keep in mind here that Canada also has a history of both efficient and inefficient, of effective and ineffective efforts in the national security arena, some of which have come to light, and from which important solutions have been diagnosed as the result of commissions of inquiry. Think here of the Air India inquiry, looking at the sharing of information between the RCMP and CSIS, or in the US context, the 9/11 Commission report that led to a host of changes to how national security agencies in the US cooperate and share intelligence. Having said all of this, in the context of government or any large organization, I think a quote from one of my favorite legal philosophers, if you'll bear with me, Lon Fuller, perhaps best tells the story of why transparency is so valued in the national security context for efficiency reasons. And that quote goes as follows: "Most injustices are inflicted not with the fists, but with the elbows. When we use our fists, we use them for a definite purpose, and we are answerable to others and to ourselves for that purpose. Our elbows, we may comfortably suppose, trace a random pattern for which we are not responsible, even though our neighbor may be painfully aware that he is being systematically pushed from his seat. A strong commitment to the principles of legality compels a ruler to answer to himself, not only for his fists, but for his elbows. In the national security context, I interpret this to mean that we must first identify the source of the elbows and then the damage in order to ensure accountability and improve on clumsy efforts and make them deliberate and effective. And that is the role of transparency in this process, to ensure that democratic accountability, to compel the rulers to answer for both their fists and the damage of their elbows, to answer for what was done wrong by accident or intentionally, to answer for mistakes along the way, and ultimately to improve matters going forward, which of course is one of the goals of this inquiry. The value of transparency then is, in part, to instill within democratic institutions, I think this is very important, the trust and legitimacy necessary to justify the powers with which today's security agencies are endowed. Returning to Fuller, at a minimum, a person will answer more responsibly, this is a quote, if he is compelled to articulate the principles on which he acts. But it is only through this transparency that the ruler is truly so compelled. Transparency requires reason giving, and reason giving compels an articulation and a justification of the principles on which agencies act in support of our national security and, more fundamentally, our democracy. So that's a high-level overview of the interests, as I see them, legitimate interest in keeping information secret on the one hand, and the value of transparency, particularly in the national security context. The question, of course, then becomes the much more difficult one, which is, how is this all done? And again, perhaps this time instead of the professorial answer, I'll give the lawyerly answer, which is, it is done by keeping in mind and applying these broad principles on the role of secrecy and transparency and their values. But in practice, that understanding will then inform a nuanced case-by-case analysis of the issues at hand. In this regard, at least on the topic of commissions of inquiry and secrecy versus transparency, let me end with some brief lessons from the past in my study of inquiries. First, commissions of inquiry have a long history of managing and collecting such information in intelligence environments where confidentiality obtains. To varying degrees, we have done this effectively, and our past inquiries provide many lessons for the present, far beyond what I have time to go into now. But it is possible. Let me offer, nevertheless, a few more concrete lessons. First, it is absolutely clear from these inquiries that they must protect sources and methods where there are legitimate risks. They must respect the efforts of state agencies to do so, particularly where the law so compels. At the same time, when such information was received and it influenced commission decisions but cannot be made public, one can include in the final report the extent to which findings relied on or were modified by or substantially modified by non-public information, and why, and even why it was, why the information was deemed credible or not, and if possible, a summary of sorts might be offered in the public report of the type of information or the justifications for why reports were relied on, whether there were multiple sources of reports providing the same type of information, which might increase the credibility, and so on. For example, the expert fact-finding report by Stephen Toop in the Aurora inquiry stated that his findings were, in his case, simply not modified by the secret information that he received. Helped the public, to my mind, greatly understand the basis for his conclusions. Similarly, whether heard in public or private, to the extent possible, and particularly where it influences proceedings, assessments of credibility of all witnesses is key. That includes government witnesses and witnesses in camera and witnesses providing information through documents as well, if necessary. Similarly, the reliability of those reports relied upon by the Commission must be considered and, again, explained where possible. This includes an understanding of intelligence language and standards, equivocations in reports, the extent to which they are supported by other sources, and so on. This was all done in the Aurora inquiry, but also most international and domestic commissions of inquiry that have been successful. Of course, judges tend to be extremely good at this, but I think it bears mentioning because we must not lose sight of it outside of the courtroom as well. At the end of the day, believability and the coherence of the story must be explained, even if all the details cannot. In the end, commissions of inquiry are set only on important issues and are often, as in cases like this, one of the few sources of transparency and thus accountability. So they must be willing to push on behalf of all of us, push to get the full picture, push to share as much of it as possible with the public, push to explain to the public where they legitimately cannot provide further details, push to improve efficacy, push to improve propriety, push to get the best picture of the factual landscape from which to judge existing laws and policies, but also, where necessary, to recommend new laws and policies. To return then to the earlier quote from Professor Roach, inquiries must push to allow the public to see as much, quote, information as is consistent with genuine national security concerns about protecting sources, methods, and relations with foreign governments. I might end with a final lesson for the inquiry itself because I think it's an important one. That is, in my study of commissions of inquiry, domestic and international, it's clear to me that commissions must, at the end of the day, take responsibility for a lack of information, either that they were not provided or to which they had access but cannot discuss. They can push for more transparency, of course. They can blame parties for non or incomplete compliance, for over-classification should it come to that, or for anything else besides. But at the end of the day, an inquiry that does not have access to relevant facts must treat that as a limitation of the inquiry itself. Put simply, bad facts make bad law and policy, and bad or no facts make equally bad commission of inquiry findings and recommendations. In sum, there will be some limitations at least on the inquiries in terms of the facts available that they can provide publicly, and that must be treated both with respect and as a possible limitation of the process. Like it or not, the alternative is to undermine the credibility of the enterprise. Thank you.
Thank you, Professor Nesbitt. If I can follow up on one of the points you made earlier in your presentation, you told us about how generally laws and institutional mores and cultures tend to prioritize secrecy over transparency. And you spoke of how that tendency manifested itself in the Arar inquiry. Do you have any suggestions or ideas for a commission operating within this reality?
For sure.
I do have a few. One of them is to do as much, and obviously there are timing issues at play in virtually every inquiry, and particularly in this one, but to do as much legwork as possible in advance. And so the Arar inquiry was very clear about that. They said as much as can be done to negotiate the release of information or to understand why it's not going to be able to be released in advance, the better. Litigation in federal court, for example, which Professor West will discuss, if it happens, it happens. If it's necessary, it's necessary. It really benefits no one in the process. And so the pre-trial conference, as it were, that can do some of the work and the information gathering before the negotiation beforehand is extremely effective. I will add, because we have an excellent article by an individual who prosecuted a number of the terrorism cases in Canada, and he said exactly the same thing with respect to courtrooms and how to prepare for national security cases. And that is that he spent, and I won't get the exact time right, but 6 months to a year in advance preparing for the release of information such that they had pre-screened as much as possible. Again, there are limitations to how much that can be done, but at the bare minimum, an explanation as to why it's important and a reminder as to why it's important to the government, and of course, a process like this to understand what is not going to be made public, I think are two important factors that might be undertaken to help the process.
I saw, Professor West, that you may have an answer to this as well, but I wonder, given the time, if we should take our morning break and return with Professor West's presentation following the break.
Thank you.
Order, please. À l'ordre. The hearing is in recess for 15 minutes. La séance est en pause pour 15 minutes. The Commission will be resuming momentarily. Order, please. À l'ordre, s'il vous plaît. This sitting of the Foreign Interference Commission is back in session. Cette séance de la Commission sur l'ingérence étrangère a repris.
Thank you. Good morning again. We'll now turn to the presentation of Professor Leah West. Leah West is an associate professor at the Norman Paterson School of International Affairs, where she teaches graduate courses on national security law, international law, counterterrorism, and ethics. She is co-author, along with Craig Forsees, of National Security Law and a co-editor of Stress Tested, the COVID-19 Pandemic and Canadian National Security. In addition, Professor West is a practicing lawyer working in the areas of criminal, quasi-criminal, and administrative law. She previously served as counsel with the Department of Justice, National Security Litigation and Advisory Branch. I should note that Professor West will be referring to a PowerPoint this morning. The PowerPoint is available currently on the Commission website in both French and in English. Thank you, Professor West.
Thanks. And I'll just say, I apologize for the density of these slides. I'm not going to really speak to the slides, but I prepared them with the hopes that they could be taken and used by the parties and public. So I will be speaking, but they're more for when you're not listening to me and you want to refer back to any of these concepts. So really what I'm going to start to talk about today is how Parliament, with the help of courts, have attempted to implement these broader principles that were articulated both by Professor Trudel and Nesbitt earlier this morning into statute and common law. So I'm going to start with the concept of injury to national security, and this is something that Professor Nesbitt already talked about a bit, so I won't go into significant detail, but I want to begin by describing what I call the core secrecy preoccupations, some might call them obsessions, of the government in the area of national security. And in so doing, I draw on statements made regularly in government affidavits justifying non-disclosure in court proceedings. And I suspect that this is something that you will hear a lot about in the coming days from other witnesses. So when making national security claims, security services focused most often on the importance of secrecy in protecting sources and methods. So this is a term you heard from Professor Nesbitt. And so, for example, the Canadian Security Intelligence Service, or CSIS, will strongly oppose disclosure of information that may identify or tend to identify employees or procedures or methodology, or that identify or tend to identify investigative techniques and methods of operation, or identify individuals and groups and issues of interest to the service. Among the most sensitive security service secrets are those of the identities of human sources, as well as the information and content they've provided. As a security intelligence service, every action taken by CSIS, regardless of the threat under investigation, is governed, to my mind, by three key considerations, or like I said before, preoccupations. First, unlike typical policing, security intelligence has national and international dimensions. The threat actors, the influences, the consequences, and the theaters of operation demand liaison and information sharing with foreign and domestic partners of all types, often under a demand for secrecy. And as a net importer of intelligence, a term you've already heard, and I'm sure you will hear again, maintaining strong relationships of trust with Canada's partners is vital to our national security interests. Second, the constant fear of penetration by a foreign agency or a threat actor demands unrelenting vigilance and creates an obsessive need to safeguard employees, sources, and investigative techniques. And third, the ultimate aim of security intelligence organizations is not public recognition for their successes or to even make citizens aware of the threats that they've faced or that they've been threats that have been thwarted. The aim is the collection of information about people and organizations who seek to obscure their true intent, necessitating the careful use of deceit, manipulation, and intrusive technology, all without violating the rights and freedoms the agency has been established to protect. So I'll just reiterate that they're not in the job of publicizing their wins, nor is it their job necessarily to speak about threats to Canadians. First and foremost, their job is to collect intelligence to help government, decision, and policymakers do their jobs and make informed policy decisions. Their advice, therefore, is not written or shared with disclosure to the public in mind, except for in very specific cases. Now, I mentioned the concept of being a net importer of intelligence, and it is implying this third-party rule, or also a rule known as originator control, that we see concerns arising from this reality at work. The third-party rule means that a state agency who provides the information to a Canadian agency like CSIS retains control over its use and its distribution, even after sharing it with that partner. This rule can and has been formalized between Canada and its allies in formal information sharing agreements, but can also be done on a case-by-case basis. The purpose of the third-party rule is to protect and promote the exchange of sensitive information between Canada and foreign states or agencies. The interest is to protect both the source and the content of the information exchanged in order to achieve that end. Information sharing agencies exercise originator control through the use of caveats. And caveats, as described by the Arar inquiry, are written restrictions on the use and further dissemination of shared information. Now, of course, there is no guarantee that a recipient of information to which a caveat is attached will honor that caveat. The system is based on trust, and caveats are not typically legally enforceable. However, the ability and willingness of Canadian agency to respect caveats and seek consent before using information will affect the willingness of others to provide that information to Canada in the future. Thus, these caveats are taken very seriously. The courts are generally sensitive to this concern, but there have been occasions where, at the very least, courts have expected Canadian security agencies to seek foreign service authorization, to simply ask the question, may we disclose this in these proceedings, or to relax caveats permitting disclosure. Canada has sometimes been reluctant even to do that for fear that asking for the relaxation of caveats signals unreliability to a foreign partner. There have been instances, most notably in the immigration security certificate context, where the government has withdrawn a case when faced with a court order that it disclose information subject to a third-party rule. Another important concept is that of the mosaic effect. Now, the mosaic effect is not an information sharing rule, rather it's a concept that must be understood when applying or upholding redactions to information subject to public disclosure. The mosaic effect posits that the release of even innocuous information could jeopardize national security if that information can be pieced together with other public information by a knowledgeable analyst. Considering advances in data analytics, this concept is truly not hypothetical, but one security and intelligence agencies seek to capitalize on a routine basis, even our own. So we must expect the same from adversary nations. As such, assessing the damage caused by disclosure of information cannot be done in the abstract or in isolation. It must be assumed that information will reach persons with a knowledge of service targets, and this informed reader can piece together unrelated or seemingly unrelated information. Thus, while a word, phrase, date, etc., which may not itself be particularly sensitive, could potentially be used to develop a more comprehensive picture, aka a mosaic, when compared to information already known by an informed viewer or available from other sources. And the mosaic effect has, again, long been recognized by Canadian courts. However, courts have sometimes expressed skepticism about its uncritical use. After all, the mosaic effect could conceivably be used to deny access to any and all information if taken to its logical extreme. And so the federal court now requires more than simply the invocation of the mosaic effect or reference to it, but rather also sufficient reasons to support its application to a particular piece of information. So now I'll turn to something that you will all hear a lot about I'm sure, in the next week, which is Section 38 of the Canada Evidence Act. So, and the actual workings of this scheme. As noted, Section 38 of the Canada Evidence Act creates a special privilege permitting the government to deny parties access to potentially injurious information and sensitive information in proceedings, and these are all defined terms. Section 38 is not the only privilege relevant to national security practice. As we heard, some information may not be disclosed because it is subject to cabinet confidences or solicitor-client privilege. There are also two distinct privilege schemes that support the non-disclosure of information that could reveal the identity of people or organizations who have provided.
I'm sorry, Professor, I have to interrupt, but because we have, yes, exactly. Okay. If you could just sure, take your time. Thank you.
There are also two distinct privileges that support the non-disclosure of information that could reveal the identity of people or organizations that have provided assistance to CSIS or CSC in exchange for a promise of confidentiality, and I'll cover those later. And of course, there are distinct common law and legislative privileges that apply to criminal proceedings that could potentially apply here, such as common law informer privilege, but are less likely to be apparent. All that being said, the scheme that is most relevant to this commission is Section 38, and key to this legislative scheme is the concepts of potentially injurious information and sensitive information, both defined using what are frankly sweeping terms. Potentially injurious information means information of a type that, if it were disclosed to the public, could injure international relations or national defense or national security, whereas sensitive information means information relating to international relations or national defense or national security that is in the possession of the Government of Canada, whether originating from inside or outside Canada, and is of a type the Government of Canada is taking measures to safeguard. Where such information might be disclosed in a proceeding, meeting before a court, a person or a body with jurisdiction to compel the production of information, like the Commission, the Canada Evidence Act sets out a series of steps that must be followed to affirm and protect the information which is alleged to be privileged. In general, the first step in the Section 38 process is one of notice, meaning any person who is in connection with a proceeding is required to disclose or expects to disclose or cause the disclosure information must notify the Attorney General where that information is sensitive or potentially injurious information. There is an exception to that rule that applies in this case, and that is when potentially injurious or sensitive information will be disclosed to an entity for a defined, predetermined purpose.
I'm sorry, Professor West, to interrupt again. If we just,
It's so boring. Okay.
not to us. It's because you,
Okay.
because you're so familiar, but for all of us, we're taking careful notes. So, thank you.
There is an exception to that rule that applies in this case, and that is when potentially injurious or sensitive information will be disclosed to an entity for a defined or predetermined purpose and listed in the schedule of the Canada Evidence Act. In this case, the Governor and Council issued an order in Council amending the CEA schedule last year, authorizing the disclosure of sensitive or potentially injurious information to the Commissioner so that she may exercise her duties. Importantly, however, this does not mean that the Commissioner is now at liberty to disclose such information publicly. Should she wish to disclose information publicly information over which the government maintains national security claims, notice would have to be given, presumably to PCO, who would then inform the Attorney General, who would then initiate the Section 38 process. Once notice is given, say in the concept of the Commission of Inquiry, the Commissioner may not disclose the information subject to the notice, the fact that the notice has been given, or that an application to the federal court to affirm the non-disclosure has been made. Alternatively, if the Attorney General and the party seeking to disclose the information, in this case the Commission, enter into some form of agreement about disclosure, under the law that too may not be revealed publicly without the Attorney General's consent. Of course, the Attorney General can always agree to allow the disclosure of the information in question, or that notice has been given, or the fact that there is an agreement. And this does happen from time to time. However, should the Attorney General not agree to release the information, or there's no agreement reached with the party seeking disclosure, they must bring an application, so this is the Attorney General, must bring an application to the federal court to affirm the non-disclosure. These applications may be heard entirely in camera and ex parte by a designated judge of the federal court, meaning a judge who is experienced and specifically assigned to hear national security matters. That said, it is often the case that there will also be public hearings where the party seeking disclosure can present their arguments, and the government will often present some public argument in support of non-disclosure. And that's typical of the case where the parties don't have security cleared lawyers that can argue in closed, or where the parties themselves haven't seen the information that they're seeking to be disclosed. It might work a little bit differently in this case, where you have security cleared counsel that have already seen and had access to the information that they're seeking to disclose publicly. So presumably, rather than having a public hearing where counsel for commission would make arguments, all of that could be done in closed potentially. Often the case is that the designated judge will assign a top secret cleared, what we call amicus curiae, which essentially means friend of the court, to assist the court by making arguments in the closed portion of the applicant and allowing it to be more adversarial. The amici will be privy to the parties' public arguments and also have access to the classified information. Again, if the commission were to go seek disclosure that the AG brought a claim for in Section 38, that process might be a little bit different because, again, we have security cleared counsel who could advance the counsel's own arguments in the top secret proceedings. Essentially, what typically happens is that the amici, or in this case, potentially counsel for the commission, and government lawyers try to negotiate what information is contentious and needs to be deliberated in front of the judge. But again, that process is usually when the outside parties are asking for information, a swath of information over which they have not seen. So again, in this case, we could expect that deliberations would probably have already happened before you're getting to the point of going before a federal court judge, but this could still potentially happen even after notice and an application begins. So for where disagreement remains, the amici, or potentially counsel for the commission, will make arguments against a government's claims for non-disclosure. And importantly, when hearing arguments for or against non-disclosure, the judge is not bound to typical rules of evidence. Rather, the designated judge may receive into any evidence anything that, in their opinion, is reliable and appropriate, and may base their decisions on that evidence. Typically, evidence includes affidavits or testimony from government witnesses articulating what injury would arise if the information in question was disclosed. And often, amicus will cross-examine the witnesses on their evidence. This evidence and argument is aimed at helping the judge decide what can and cannot be disclosed in the particular circumstances. To make that determination, the Federal Court of Appeal enunciated a tripartite test for adjudicating Section 38 claims in a case called Ribbage. So you often hear this term, the Ribbage test, and it's a three-part test, as all law tests are required to be. This first step in the test is to assess the relevance of the information in question to the underlying proceeding. That burden rests with the parties seeking disclosure. This is, again, typically a pretty low bar, and I imagine in this context where the commission is seeking disclosure of additional information, where they know what that information is and why they want it, that would be a very low bar. In some cases, the commissioner could be seeking the disclosure of her very own words or findings. So relevance would probably be an easy one to meet in this context. Second, the second test, or step in the test, is the question of injury. The designated judge must determine whether the information issue would, not could, be injurious to international relations, national defense, or national security if disclosed. This demands demonstrating probability of injury, not merely the possibility, and the burden on this rests with the Attorney General of Canada. Importantly, this is not a question of the information in the aggregate. The judge will typically go line by line, sometimes word by word, to make this assessment. On this point, they will hear counter-arguments from the amici, or in this case, commission counsel, rebutting the government's claims. And ultimately, the court will tend to give more weight to the government's claims as the expert on this issue. Still, those claims must have a factual basis established by the evidence. The third element of the Ribbage test, and the most challenging typically, is assessing whether the public interest in disclosure outweighs the public interest favoring non-disclosure. So in here, the public interest in disclosure would be the mandate of the commission, and the public interest in non-disclosure would be the interest in the injury to national security. And here, the burden would rest with commission counsel. When arriving at this conclusion, the federal court judge will often consider if there are ways to minimize the threat and maximize the public interest by issuing summaries or partial redactions of information. Again, this is not done in the aggregate. The designated judge will go line by line, potentially word by word, making their decision about where the balance lies. Once the judge has engaged in this thorough balancing exercise, they will either make an order authorizing the release of the information, authorizing the disclosure of all or parts of the information subject to conditions or in summary form, for example, or confirming the non-disclosure of the information. Importantly, an order of the judge that authorized disclosure does not take effect until the time provided to grant an appeal or to seek an appeal has expired. This means, of course, that the federal court order is not necessarily the end of the matter. First, a party can appeal a decision to the Federal Court of Appeal within 10 days of the order, and all the way up to the Supreme Court of Canada if they are so inclined. The process and the test would be the same except done before 3 judges of the Court of Appeal or 9 judges, up to 9 judges at the Supreme Court. If it is the government appealing the decision or the disclosure order, the judge conducting the appeal can make an order to protect the confidentiality of the information that the federal court ordered to be released. Alternatively, the Attorney General of Canada may personally issue a certificate that just outright prohibits the disclosure of the information in connection with the proceeding for the purpose of protecting national defense, national security, or international relations. That certificate may only be issued after an order or a decision that results in the disclosure of the information has been made. So essentially, the process would look like this. The AG lost on some of its claims for Section 38 privileges to be maintained, and the court ordered that in the public interest, certain amounts of the information that government sought to protect had to be disclosed. The government could appeal, or the Attorney General could issue a certificate prohibiting the future disclosure of that information, and that is essentially the end of the matter. There is an element of being able to test the appropriateness of that certificate, but essentially it's a bit of a fiat. In short, the AGC is holding a trump card, and if played, then notwithstanding the federal court's order or their finding, the information must be withheld in accordance with the certificate. So far as we know, this card has only been played once before in a criminal trial involving allegations of espionage. Why has that trump card only been played once? Well, I would argue it's because Section 38, as cumbersome and potentially complex as it seems, is actually a rather flexible process, mostly thanks to the actions of the federal court to ensure it is so over the past decade and a half. That process creates, and I'd argue incentivizes, collaboration between the parties to find compromises at 3 points: before an application is made to the federal court, before the court hears arguments on the Ribbage test, and when the judge is crafting their order. As we will see, this is not the case for information subject to human source privilege claims. Nevertheless, the downside of this process, like a lot of good bureaucratic processes, is the length of time it takes to complete. Thus, avoiding the full adjudication of national security privilege claims is certainly something that all parties should seek to avoid. It may be flexible, but this process is very rarely quick. This was exemplified in the ARAR Commission, as Professor Nesbitt alluded to earlier, when Justice O'Connor sought to disclose information over which the Attorney General maintained national security claims in his factual report. That commission of inquiry had a similar mandate to this one when it came to national security claims and disclosure. Like, as a commissioner, if Justice O'Connor was of the opinion that the release of part or of a summary of classified information presented in camera would provide insufficient disclosure to the public, Justice O'Connor said he would advise the Attorney General of Canada which would in turn satisfy the notice requirement set out in Section 38 of the Canada Evidence Act. Justice O'Connor set out a whole process for hearing evidence in camera. He determined that he would apply the Ribbage test when making determinations about national security claims. He also heard evidence regarding the need for non-disclosure of certain information, including from an independent advisor who was a former CSIS director, and he appointed two experienced amicus, one of who's in this room, to challenge the national security claims in the in-camera proceedings. So essentially, the commissioner himself applied the same tests as a federal court judge would when hearing information from government witnesses and determining whether that information could be included in summaries of those hearings or in his final report or broader work. After the main evidentiary hearings concluded, both public and enclosed, Government counsel and the commissioner held a series of discussions about what could be included in his final factual report and how, and they were able to resolve the vast majority of disputes. Matters that were still unresolved, it got bumped up to senior government officials, including deputy ministers who were consulted, resulting in the government ultimately authorizing the disclosure of certain passages of the commissioner's report, notwithstanding the potential injury. The ministers were then briefed on what remained, and ministers decided not to authorize certain disclosure, regardless of the fact that the commissioner was of the opinion that their disclosure was in the public interest and was necessary to recite the facts surrounding the Arar affair fairly. With that understanding, in September 2006, two final reports were submitted by the commissioner to PCO, one classified, the other public. Redactions were applied to the public report and it was released to the Canadian public. In December of 2006, the Attorney General filed a Section 38 application to withhold approximately 1,500 words from the public report, which was less than 0.05% of the total report. The designated judge appointed in the federal court by the federal court heard testimony, 2 days of public hearings, 4 days of open hearings, and ultimately issued his decision in July of 2007. The designated judge was Justice Noel, and he agreed in part with the Attorney General and in part with the Commission. And consistent with his order, the final report was released in September 2007 with fewer redactions. In total, the adjudication of 1,500 words took over a year. Notably, in his decision, Justice Noel set out the factors he considered when balancing the public interest in the context of a commission of inquiry. Several of them apply in all contexts, but the one that he added for the purpose of the commission of inquiry was whether the redacted information relates to the recommendations of a commission, and if so, whether the information is important for the comprehensive understanding of said recommendations. In his final report, Justice O'Connor reflected on the national security claims made by the government and on their impact of the work of the commission, and we heard some of that from Professor Nesbitt. As far as process, he was satisfied that his modified approach, not his initial approach, which one might have called the ideal approach, worked as best it could in the circumstances. However, he made clear that the public hearing part of the inquiry could have been made more comprehensive than it turned out to be if the government had not, for over a year, asserted NSC claims over a good deal of information that eventually was made public. He noted that throughout the in-camera hearings and during the first month of the public hearings, the government continued to make national security claims over information that it had since recognized may be disclosed publicly. This overclaiming occurred despite the government's assurances at the outset of the inquiry that its initial claims would be reflective of its considered position and would be directed at maximizing public disclosure. The government's initial national security claims, said Justice O'Connor, were not supposed to be an opening bargaining position. In effect, overclaiming by the government exacerbated the transparency and procedural fairness problems built into a commission addressing matters of national security and promoted public suspicion and cynicism. He warned that it is very important that at the outset of the proceedings of this kind, every possible effort be made to overclaiming. Now, I obviously agree with all of that, but I do want to make one point. It is impossible for those who are making redactions at the outset of a commission to know what the commissioner's findings and conclusions are going to be. And some of the information that is redacted may prove to be very important to ultimate findings or making sense of those things. But the person making the redactions does not know that. So there will inevitably be an element of back and forth. There will be no case where it's simply obvious to someone tasked with redacting a document to know the ultimate weight a commission of inquiry will put on that piece of information. So I think obviously we need to take the findings of Justice O'Connor to heart, and the government should not start with an opening position. But I think that we need to remember that some of this information will prove to be more important to your findings, and as a result may result in a change of government position on redactions. Okay, I'll turn now to the two regimes that cover human source privilege. The first is a scheme set out in Section 18.1 of the CSIS Act. CSIS relies on human sources for information, and indeed, what sets CSIS apart from other law enforcement agencies is its focus on the development and recruitment of human sources. These sources are not, however, informers in the legal meaning of the term. The Supreme Court of Canada held in 2015 that the class privilege afforded police informants did not extend to CSIS human sources. So Parliament responded to that finding by amending the CSIS Act and to create a new statutory privilege for human sources. The CSIS Act defines a human source as an individual who, after having received a promise of confidentiality, has provided, provides, or is likely to provide information to the service. So there's two parts to this definition. There is the promise of confidentiality made and the promise of information. So it doesn't even have to be that the information was provided, but a promise that information would be made in exchange for that promise of confidentiality. Section 18.1 of the CSIS Act now prohibits the disclosure of the identity of a CSIS human source or any information from which the identity of a human source could be inferred in a proceeding before a court or person or body with jurisdiction to compel the production of information, like the Commission. While the privilege only came into existence in 2015, it does protect those who fulfilled the definition of a human source before the passage of the legislation. And human source privilege can only be waived with the consent of both the source and the CSIS director. Moreover, the application of the privilege can only be challenged on essentially three grounds. One, that the individual is not a human source, so they don't meet that definition. Second, that the identity of this human source could not be inferred from the information in issue. Or third, and this really only applies in criminal context, that the identity of the information protected by the privilege is essential to establish an innocence accused in a criminal trial. So not applicable here. So you're dealing with two situations. The person is not a source, or the information could not reveal their identity. Other than that, there is no grounds to challenge the disclosure of human source information. There is no balancing here. Any hearing respecting the privilege is to be held in camera and ex parte. The other form of source privilege, I haven't found a good shorthand for this, is set out for in the Communications Security Establishment Act. In Section 55 of that Act, Parliament has prohibited the disclosure of the identity of a person or entity that has assisted in or is assisting the CSC on a confidential basis, or any information from which that identity could be inferred in a proceeding. Section 2 of the CSC Act defines an entity as a person, group, trust, partnership, or fund, or an unincorporated association or organization, and includes a state or political subdivision or agency of a state. Again, waiving this privilege requires the consent of both the assisting person or entity and the CSC chief. And I'm not aware of this type of privilege being raised in at least a public legal proceeding, so we don't have any case law on it. Importantly, however, unlike 18.1 of the CSIS Act, the claim of privilege under the CSE Act, claim of privilege under the CSE Act triggers the Section 38 process, but it short circuits the Ribbitt's test, or that's how I read it. Instead of applying the three-step Ribbitt test, a judge may only order disclosure where, again, the person or entity is not actually assisting the CSE on a confidential basis. 2, their identity could not be inferred from the disclosure of the information, or again, it's necessary to establish the innocence of the accused in a criminal proceeding, which is inapplicable in the context of this commission. Section 18.1 of the CSIS Act and Section 55 of the CS Act are far more akin to the common law informer privilege and much more restrictive than national security public interest privilege created by Section 38. The parties and the judge do not have the same capacity to find compromise on the release of information about human sources. There is no balancing. If the information could reveal the identity of a human source, neither the Attorney General nor the judge have the authority to disclose it. The reason for this being that we are talking about the need to safeguard human sources from threats to their lives or the lives of their loved ones, ensure that others will continue to take the risks of providing critical information and assistance to our national security agencies. With all of that said, I'll look forward to your questions.
Thank you very much, Professor West. Perhaps I can begin by just clarifying the types of in-camera or closed proceedings that might be involved either in this commission or following the work of this commission. So you mentioned at least 2 types of closed proceedings, one where that I understand would be led by the commissioner, and one that would take place in federal court. Can you help us understand the difference between those proceedings and where they might be or why they might be employed?
So I'll start in order. So it's very likely, even looking at the rules of procedure for this commission, that there will be testimony heard in closed proceedings or in camera. Meaning that it'll be not only closed to the public, but presumably closed to many of the parties. And it'll be where I imagine predominantly Government of Canada witnesses would provide information relevant to the commissioner's mandate that they deem privileged, subject to confidentiality claims. And this would be a forum without the public where the commissioner and commission counsel could question government witnesses about their evidence. I mean, it would be presented by government counsel, but you could also cross-examine and question them on their evidence. And presumably, again, I don't know your process, but you will have a sense of the types of questions the parties would want asked as well, and you could pose them to government witnesses without the parties being present so that the commissioner would have the benefit of those answers. In the Arar Commission, what happened as well was that during that process, government witnesses would make argument about why the information they were providing at the time needed to be maintained under national security confidentiality. And Amici, appointed in that case, could question the witnesses about that specific element of their testimony. I don't suspect that that will happen in this case. I don't know what your process is going to be. But you have security cleared counsel that are experienced Amici who could test that kind of evidence as need be throughout the process. But the reason why that was done in Arar was because Justice O'Connor wanted to be able to produce summaries of the evidence that was heard in camera publicly for the benefit of the parties. He eventually abandoned that practice because just the sheer process of hearing the evidence about what needed to be claimed, having that be tested by Amici, making a decision about a summary, then working with government lawyers to try to create some sort of agreement on what the summary would be. They actually never reached an agreement. The Attorney General refused to allow some of that information out, and it led to Section 38 proceedings. And that process, again, is long and drawn out, and Justice O'Connor in that case said, I'm not doing this anymore. And he actually changed his rules of proceeding to say, I'll do summaries maybe, may issue summaries, but he decided that really with the time that he had and the length of process that took, he wasn't going to do it anymore. So future in-camera evidence was not subject to that process. He just heard the evidence. I believe the Amici did still push on evidence or claims of national security, but they didn't enter in this process of producing summaries anymore. Then what happened in Arar, and this answers your second part of the question, it was they got to the point where the commissioner was ready to release his factual findings. And like in this commission, he was instructed to have both a public and a confidential version of his findings on the factual element of his mandate. And he wrote up both, and he wrote one with the intent of it being public and one with the intent of it remaining classified. And the government disagreed, and there was, again, negotiations back and forth, but ultimately disagreed with some of the information he wanted released in that public report. It wasn't that Justice O'Connor necessarily disagreed with the injury, but said it was too important for the public to not have that information. And then they went through the Section 38 process at the federal court. And that's when a court was appointed, a federal court judge was appointed and went through the whole legislative proceeding. And that process took an extra year. So you saw the ribbage and the balancing test in the Arar inquiry take place in both instances, but eventually it was abandoned by the commissioner because it was too cumbersome. And it was left really for the federal court to adjudicate that last little bit of information that the commissioner and the attorney general couldn't agree on had to be made public.
And I think you've anticipated perhaps my next question or what I was going to ask you, but in this, the process, you spoke of the compromise and negotiation that happens before, or is encouraged to happen before a Section 38 application occurs. Do the legal principles that you identified, that were identified in Ribbage, can those inform or to play any role in the negotiations that happen in respect of national security confidentiality claims outside of a formal Section 38 application?
Oh, absolutely. And I think what you end up getting is one side, the party seeking disclosure, arguing vehemently in the public interest why it's important to release that information, potentially notwithstanding the injury, and the other side arguing that the injury is too grave, or potentially trying to minimize the importance of the public interest. And that are, really at the end of the day, you're trying to get the difference, the delta down, so that you can get a compromise on how that information is released. And often it could simply be a rephrasing of a statement or the removing of certain factual elements of a conclusion. And that negotiation takes place based on that kind of balancing, constant balancing between the public interest and how important that information is in the public interest of the commission's mandate versus the potential injury. And so I think that's throughout the negotiations, which will take place, I think, before, after, during the writing of any report coming out of this commission. That's always kind of the balance. And it will be up to the Commission Council to recognize injury and balance that themselves when seeking to push for public information. And I hope that it's also the government's position to also recognize the public interest and the mandate of the Commission when making injury claims so that they can come to some sort of compromise.
Thank you. You mentioned that in the Arar inquiry, amicus curiae, or a friend of the court, was appointed to make submissions to challenge national security confidentiality claims in the commission's in-camera proceedings. Can you explain how or whether the role of amicus in that type of proceeding would differ from commission counsel?
So it's my understanding in the Arar inquiry, the counsel appointed had very little, and even Justice O'Connor had very little experience with national security matters. And so part of the justification for having amicus was someone who was experienced in listening and questioning government claims of national security, who's familiar with the concepts and confident in testing those assertions, which was not something that they had built into the council team initially. That's very different in this case, where you have several people who are top secret cleared counsel and who do serve that purpose in other hearings. And so I would argue that it's potentially not necessary here because you have counsel who have that ability and have that confidence to challenge and accept, where necessary, claims of national security privilege.
Thank you. We are approaching the lunch break. In this afternoon, we will have an opportunity for the participants who have been sending us, I hope, and I will encourage participants over the lunch hour to continue to send questions that we can put to our panelists. We will have the full afternoon to answer and address those questions. In listening to your presentations, and perhaps just to get people thinking about other questions, I wanted to pose one myself. We heard yesterday in a presentation from Commission Counsel, and I anticipate we will hear from witnesses later this week, that the classified information relevant to the Commission's work in this case is particularly sensitive, very, very secret, as it was described yesterday, and that disclosure would be highly injurious to the national interest. At the same time, we are, and as we are reminded by a number of the participants, the public interest in being fully informed about the integrity of our elections is difficult to overstate the importance of the public interest in that type of information, given its central role to our democracy and public confidence in our government. And so I'd ask the panelists to reflect on and share your thoughts on how the Commission, or how we should, these relative public interests in the disclosure of information on the one hand and transparency and the protection of national security be weighed in this context, admittedly a challenging context. So I believe we'll break and returning at 2 p.m. from lunch.
Order, please. Alors, s'il vous plaît, the sitting of the Foreign Interference Commission is now on break until 2 p.m. Cette séance de la Commission sur l'ingérence étrangère est en pause jusqu'à 2 heures. The Commission will be commencing shortly. La Commission commencera sous peu. Order, please. À l'ordre, s'il vous plaît. The sitting of the Foreign Interference Commission is back in session. Cette séance de la Commission sur l'ingérence étrangère a repris.
bon après-midi.
Good afternoon, everybody. Thank you very much, and thank everybody.
Received during over the course of the lunch hour. We will do our best to make our way through the questions in the time we have this afternoon. Let's begin with turning to the question that I posed before the break. Perhaps a difficult question, or perhaps you'll tell us how easy it is. How, in the context of this commission, where both the national security, the public interest in maintaining secrecy and the public interest in transparency both weigh quite heavily, how do we begin to balance those values? And I'll perhaps start with Professor West, as I'm looking in your direction.
That's noted. Okay. So to me, I think there's a difference in terms of what the mandate of the commission is. And the mandate of the commission is to understand not only the threat, but how the government responds to the threat of foreign interference, or did respond to the threat of foreign interference in the past two elections. At least that's the first part. And to me, coming here, there have been allegations of wrongdoing or failure on the part of the government to fulfill its responsibilities, to inform Parliament, and potentially even to undertake its mandates under the law. And I think that is different than understanding how our intelligence agencies detect the threat, how they surveil the threat, how they potentially intercede in the threat. And it's helpful to understand that, probably to understand how information that was passed to government decision makers or policy makers was made, but I don't really think it's the crux of the issue or the crux of the issue about keeping our trust in our democratic institutions. And if I was to, take this back to a ethical or there's shallow secrets and deep secrets. And the shallow secrets here are the ones about what the government did with the information. And the deep secrets is how it got the information upon which it did or did not make decisions. And to me, I think how the government got the information that it did or did not make decisions upon is the information that is the most sensitive and could be potentially most injurious to national security, and maybe doesn't need to be made public to answer that other question. Obviously, if in the commission's work you come across wrongdoing on the part of the people who are collecting the information, or something about the techniques used that were harmful to Canadian interests, that changes the equation. But I think keeping in mind the major mandate of the commission, the big questions you're asked, and whether or not the information below that, those deep secrets, is really necessary to reveal in order to allude to those other findings and make recommendations, I think would be helpful for the commissioner and the commission council moving forward.
Professor Nesbitt, your pen stopped writing first, so I'll turn next to you.
It ran out of ink, actually. No. So maybe I'll refer back to both what I said this morning and to some extent what Professor Trudell said this morning too. I think you have to start with those high-level values, the values in transparency, and the principles that we sort of discussed. Why do we have secrecy? An understanding of the need for secrecy in many cases, an understanding of the need that some of the secrecy is protecting Canadians, right? Sometimes when we don't disclose certain information, that's to protect individuals and methods of collection that protect all of us. And at the same time, understand those values with respect to access to information, transparency to the public that Professor Trudell discussed, but also that transparency is fundamental to the role of accountability, as I discussed or tried to discuss this morning, that without having access to testing information and forcing those who hold it to articulate the reasons for confidentiality, we are not able to hold them accountable, right? For, as I said, their fists or for their elbows. And so there's real value. There's real value to secrecy and there's real value to transparency. But we have to understand why that is, right? Not the simplistic notion, but the broader notions of the values that we're upholding here, why this matters, why it matters in the context of inquiries. And I say that not to skirt the issue, but because that's got to inform then a case-by-case analysis of the materials at issue. So the next step is then to test it, to test the claims. If you look at what's happened in court cases in this area, if you look at what happened at the RAR inquiry, it's you're challenging. You're not challenging because you don't trust. It's, I think as Professor Forsey like to say, trust but verify. So you're challenging.
Spider-Man said that.
Yeah. Perhaps so. So test, are the values that we say we're upholding, are they really applicable, right? Does the protection of lives actually apply here, or does it apply in theory to types of information, which maybe is less relevant here? How much do you need the information, right? So we're almost getting into, at this stage, necessarily, something that judges will be used to, a proportionality analysis of sorts. Right? Why do I need this information? Why does the public need it? How much will it inform what we have to do? How much does the public have to know about it? And that's being balanced against the legitimacy of the claims of secrecy on the other side of it. unfortunately, that leaves you with not a definitive answer in this case, but rather I guess in this case, a bit of a plea to do a case-by-case analysis, to keep in mind those broad values, as I said, but also to take seriously the context in which you're engaged, in which claims are being made.
Thank you. Professor Trudel. Any points to add to what your colleagues have mentioned?
No,
No, I have nothing to add.
with my colleague on that way to see and to organize the thinking about and the reasoning that we must operationalize to get a decision. So I'm in agreement with my colleague.
Thank you very much. Let me turn to some short, perhaps slightly easier questions that we received over the course of the break. For Professor Nesbitt, you mentioned the 5 I's. Can you explain what are the 5 I's and just expand a bit on this concept?
Of course. So Canada has a fairly well-known information sharing arrangement with what are called the 5 I's, which we are part of. And so the 5 I's are Canada, the US, England, Australia, and New Zealand. I'm right about this, right? Don't want to get that one wrong at this point. So, so what that is essentially an agreement amongst those countries in particular to be forthcoming in the sharing of our intelligence that affects democracies, Western democracies in particular, that affects those nations, to maintain, at a very broad level, good working relationships. And so what that means for Canada as a net importer of intelligence is we get more, is well known, from the 5 I's than we give out to the 5 I's, which probably to be expected. First of all, it's 4 other nations and we're one, and secondly, several of those nations are quite a bit bigger. But the implication then is that we are to some extent dependent on information received from other countries, and particularly those members of the 5 I's. I did want to say something in that regard, because that in turn has sort of 2 implications. The first implication is that we're dependent to some extent on multilateral engagement on this sort of stuff, and on the receipt of that information, and on continuing to be trusted. And so that justifies, or can justify, us protecting information from the 5 I's. The flip side of that, and I hope this isn't taken too far, but if you are dependent on the importation of intelligence because you're doing less than the other countries, it strikes me that it would be odd then to say, and we can't provide the public with information because we didn't bother to collect it ourselves. So put another way, there is real reason to say it's important within the 5 I's context to be sympathetic to claims that we need to maintain our credibility and reliability with our partners. On the other hand, we can't use it. I think it's important to ensure that it's not used as sort of a crutch.
Professor Nesbitt, someone also asked about the article that you referred to in your remarks, and because I happen to have time, I looked it up, and I believe it's Navigating National Security, the Prosecution of the Toronto 18, and that's in the Manitoba Law Journal. You can provide, it's a 2021 article. Professor West, one specific question for you. You mentioned the section 38.13 certificate which when that is issued, I forget the term that you use, the trump card or the sort of the certificate is invoked, will that decision to invoke that or issue that certificate, will that always be made public?
I would have to go back and read the statute because it's not something I've ever considered. It's my understanding that it would, but I would have to go back and read the statute to know. It would state in the statute whether or not it could be revealed publicly. There are certain things in the statute that say cannot be, as I mentioned earlier, and it would be clearly articulated in the statute. I'm sorry, I don't have the in front of me to answer.
All right. Thank you very much. I think we'll turn now to start. We've tried to organize some of the questions by theme, so I'll just pass the microphone over to my colleague to ask some questions about in-camera proceedings and related topics.
Good afternoon. So maybe a follow-up question concerning the question about the Five Eyes. We have received a question concerning the multilateral arrangements, and is there anything in those arrangements concerning disclosure of information in the context of public pressure for disclosure or court orders for disclosure?
There are in some, I know, for example, even a NATO information sharing agreement, for example, is the example we use in our textbook because it's a public arrangement, does make clear that the originator maintains control over disclosure. There's no leeway in these agreements that if the public really, really would like to know, please, whether or not that, trumps the originator control premise over the information. Essentially, usually in the agreements, it's if you want to use this for any purpose other than the purposes we've agreed to in this exchange, you need to come back and ask us. And so there may be limited allowances for information sharing beyond the agency to agency in the agreement, but it'll typically say beyond that, you need to come back and ask us. And then it is up to that country to determine whether or not the justification for you asking the question is sufficient for them to say, okay, go ahead and use the information as requested. And they may say no. Regardless of the justification asked for the request, they could still very well say no. Again, it's not a legally binding contract. A court could still order that information go out and has in some cases, in the security certificate case, for example. And then it's up to the agency to decide how they want to, proceed, either deal with the reputational impact or the relationship impact of compliance, or find some other means of, in the security certificate case, just choosing not to proceed. So, yeah, the information remains in the control of the agency who gave it. And the premise is that you will not use it unless we've agreed to the way in which you use it, regardless of the reasoning why.
And you call that the control of, is there a specific?
So either the third party rule or the originator control rule.
Okay.
Or concept.
Thank you. Donc, question.
A specific question for Professor Trudel. When we look at it from the public viewpoint, public perspective, what can be the concerns raised by the holding of some hearings in camera? When there's a commission of inquiry like this one and there's in-camera hearings, are there particular considerations in the public's eyes that can exist? Yeah, indeed. When the public is being told that hearings are being held in camera, there's a sort of a spontaneous reaction. What are you trying to hide? Why don't you just do it openly? The public is ready to accept that in-camera might be necessary in some cases. For example, daily, the courts sit in camera when we're talking about child welfare and other situations involving minors. So essentially, I would say that what can become unhealthy and a problem is when the public gains the impression that something is being hidden from them. One way of remediating that is to be as transparent as possible on the reasons for which an in-camera session is necessary. What is being protected, or national security, for example, if it's or the security of certain persons? Is it a question of the integrity of the agreements between allied countries? Another example. And then, in that case, I think that the concerns of the public are a lot easier to manage or alleviate when the public is informed correctly and loyally, so to speak, of the reasons for which things have to be held in camera. It prevents the impression that the public might have, or some elements of the public might have, that something is being hidden from them.
Turning now to Professor West or Professor Nesbitt concerning the RR inquiry. It was mentioned this morning during Professor West's presentation that the summaries were abandoned as part of the process of the O'Connor inquiry. Could you provide a bit more context as to why the summaries were abandoned in this fashion?
Sure, and for anybody who really cares to know, that Justice O'Connor actually spelled out in it, he has a ruling on summaries that was 4 pages long that explains this process. But essentially, it was the process of negotiating the information that could be released in the summary that proved to be quite lengthy. So not only did he have to go through the process of hearing evidence about why information could and could not be revealed in the in-camera proceedings itself, which would have added to the proceedings, he then made rulings on those issues, and then created a summary based on those findings, and then entered into negotiations with government lawyers about the content of the summaries, and they could never reach full agreement on the summary, ultimately leading to a Section 38 application by the Attorney General. So in the process of getting to a point where there was a summary that both sides could agree to, just took too long in the context of a commission of inquiry. I mean, in an ideal world, for every hearing that you have in camera, there would be a summary of evidence that would be put forward to the public upon which they could understand what went on. That is something that is often done, for example, in complaints made against CSIS or CSC, for example. Parties cannot be a party to them. But those processes are not under the same time constraints as a commission of inquiry. So ultimately, it came down to the ideal process of getting to a point where there was a summary, which was the process Justice O'Connor went into thinking that he would do, because it is probably the best process for managing this balance of the need to know in the context of a commission, especially for the parties. It just wasn't workable in the time frame that they had. So they chose to abandon that process of creating summaries.
And do you know if there are other strategies or techniques that could be used to ensure transparency, as much transparency as possible, where those summaries, or the ideal scenario that you just mentioned, where this is not possible?
So summaries are already a compromise, right? So we've gone from having the parties be full participants in a hearing to getting summaries of the evidence to essentially in the case of, or are not getting summaries and only getting the final factual report. And I think Justice O'Connor, based on reading I wasn't there, but based on reading it, is he decided to put the time and effort to argue and find compromise in that final factual report rather than throughout every step along the way. And to ensure that because there may be information in a summary that really doesn't need to even go into a final finding of fact, right? Like he decided to put his weight, his time, the effort of the commission into really arguing and really into focusing on transparency around the core issues that they felt were necessary to meet the public in that final factual inquiry. So rather than run out the clock on stuff that may not be all that important in the grand scheme of things, to really focusing their efforts on that which was really necessary for the commissioner to make his findings. But it's a compromise on a compromise.
If I could jump in on that, I guess just to elaborate, the one thing they did in Arar, and I think it's just a good process, is if you can't provide a summary, at least explain the evidence you're using and why you're using it. And so by that I mean, you don't have to in the final report say, I'm using this from a source in X country, but you might be able to provide something like, I'm relying on information from in-camera hearings because there were multiple sources that were independent that I find to be reliable, maybe even provide a reason, that corroborated this finding. Or, as Professor Toop did, lots of great information, but I'm not relying on it here. It's not influencing my decision. And so you're not getting a summary per se, but you're getting an understanding out there in the public in terms of what type of information might have been available in terms of what I would have been looking for credibility in the witnesses or the reliability in the reporting, whether it was corroborated, whether I'm relying on it or not. And then again, as Professor West says, focusing on that on the report, and then see if maybe you can get some of the information out as well if there's going to be a fight about that. But even if you don't, there's other ways to provide less detailed summaries to at least justify and explain your choices.
My colleague might return on the topic of in-camera hearings. So before moving to another topic, I'll let her take the podium.
I think just following up on the discussion about summaries, one of the other, or this morning, one of you mentioned the idea in terms of increasing transparency about in-camera hearings, that questioning of a witness in an in-camera proceeding might include questions suggested by participants or parties who are excluded from the hearing. In your view, should the commission provide all the parties a complete list of all witnesses who will be called? Is there a requirement of a minimum amount of notice about the topics or the witnesses who will be testifying in in-camera proceedings? Perhaps you can speak to those types of strategies that might enhance transparency in an in-camera. Those are other type of strategies that could enhance transparency in in-camera proceedings.
Let me start. So the ideal, which I don't think under the constraints of the commission you have, the ideal would be to have a special advocate or special advocates who are security cleared, who could work alongside parties, counsel for the parties, and ask those questions themselves. So we see this in a variety of administrative matters, most notably security certificate cases, where lawyers were designated to represent the interests of the parties inside in-camera proceedings. Based on my understanding of the commission, and the type of work already having been done by commission counsel, that's not feasible in this case. There would be no way for a special advocate to become fully cognizant of the underlying evidence or documentation to be able to do that job, to catch up and do that job in the hearings that are scheduled. That would be the ideal. I'm not certain it could happen here.
Before we move
Yeah.
on from that, so for people who haven't heard these different
Yes.
terms before, there's commission counsel. We heard something about amicus earlier. You've used the term special advocate. Special advocate, how would a role like that be different than that of commission counsel, for example, who is
Yeah.
cleared and able to participate in in-camera proceedings?
So commission counsel are lawyers for the commission and the commissioner, and your raison d'etre is the mandate of the commission. That may not be true and is unlikely to be true for a number of the parties. They all have different interests and might want to advance different issues based on those interests. And so the difference in an in-camera proceeding is if you were to have a special advocate, they would essentially be representing those interests, the interests of the party in the in-camera proceeding, whereas commission counsel will continue to represent the interests of the commission. Now, I'll say the interests of the commission do include the interests of the public, the broader public interest. So there would be some overlap, but it would be a more defined role for a special advocate. That's different from an amici, typically. Amici is often, as I use the term, a friend of the court. They can be given very broad mandates to take very adversarial roles, but typically they're there to provide assistance to the commissioner, to act as the commission's counsel of sorts inside a hearing. The commissioner already has counsel in this case, so that's why they're different.
And I took you off. You were going to talk about if a special advocate for reasons of practicality or other reasons isn't available, what other strategies or approaches, in this example, providing a list of witnesses, for example, a notice of the topics to be covered?
I think both of those would be critical. You may not be able to give the person's name, for example, but at least their position or role within an agency. And commission may have, a summary of anticipated evidence, for example, that the government could produce a public and private version of that summary. And that could be used to inform the parties and the interveners about the types of things that witness would speak to. And then with sufficient notice for the parties to consider, based on what they've read, what kind of questions they would like to see pursued. That doesn't necessarily mean commission counsel would pursue all avenues suggested by the parties, but those that are most prescient to the commission's mandate could possibly be taken up. I don't think I have any other recommendations. That's where I would stop.
Thank you. Did anyone else want to add to that on that topic? All right. Before we leave sort of this question of summaries and other strategies, I wanted to ask about the human source privilege you noted in section 18.1. Are summaries an available technique for providing some information about human sources as defined in section 18.1?
So this question was answered in the negative by the Federal Court of Appeal. There is no summaries available for human source information.
Professor West, perhaps just going back, and I'll ask this of all of our panelists, in answering one of my earlier questions, you talked about the commission identifying particular areas of interest, likely to be of most interest to the public. Professor Trudel, Professor Nesbitt, do you have any comments you wish to add on how the commission might best identify the areas or topics or categories of information that will be of most interest to the participants and the public? What values or principles do you say should guide the commission in determining, assuming we have to engage in some kind of prioritizing of what information is made public to the participants and to the public, how should we go about, or what should we think about? What are those big picture values we should think about in identifying the areas for that are of highest priority for the public?
Shouldn't ask me.
I guess the easy answer is go back to your terms of reference and start there. Whatever the terms of reference say is the priority of the inquiry would be guiding what sort of information you look for and prioritize.
I would only add that taking lessons from Arar, it's seemingly the issues that he was prepared to argue over was the information that was most relevant to the recommendations being made. So not necessarily the all findings of fact, but those ones that were crucial to understanding or which were foundational to recommendations being made are the ones, the type of information that the commission might really push to have made public.
Thank you. I want to turn then to some questions on that we've received on assessing harm or the potential injury to the national interest. One of the arguments we have heard or expect to hear from government, and that was mentioned in some of your presentations this morning, is that a single piece of information may on its own appear innocuous. I think addressing Professor Westwood, you're talking about the mosaic effect, but its disclosure will still be harmful when pieced together with other information. How do you suggest the commission consider this type of claim where the harm may not be immediately apparent based on the information itself? How can the government provide some comfort that this is a legitimate concern and not a sort of broad hypothetical that could be used to overclaim national security confidentiality?
So this is something that the federal court itself has dealt with, and the federal court now does say, you need to not come with just this hypothetical theory and tell me, but you need to provide some evidence as a foundation for this assertion. And so I think some of that evidence might be knowledge of how the relevant intelligence agency or foreign state might collect or analyze information, or their capacities and their priorities, and how that piece of information could trigger the use of their tools. A more sophisticated intelligence service from a foreign adversarial state might have tools known to our intelligence agencies that are capable of doing large-scale data analytics, for example, versus a different state who may not have similar capabilities. So coming to the commissioner and saying, look, in this context, this information would be very relevant to this state. They would care greatly about this piece of information because it might tend to reveal X, Y, Z, and we know them to have the capabilities to do that kind of analysis. So again, you don't know for sure that that piece of information would trigger something, but evidence to support the idea that the mosaic effect could be implicated if that information was released.
May I add?
Yes,
May I add
of
something?
course.
Je pense qu'il faut aussi
I think that when you're talking about an exhibit or about some information which could be combined to others, in the equation you have to include the possibilities that are available through artificial intelligence. Once an information is disclosed to the public, you can no longer consider in a linear way the risk that it might be combined with others. Now, and we can assume that the people who are in charge of collecting and analyzing the information, sometimes for good reasons, sometimes for reasons which may not be as good, we can assume that they now have access to technologies which enable them to infer and literally to generate information and knowledge. So we probably have to introduce in the equation a risk analysis.
l'information puisse être traitée.
That some elements of information can be processed in an AI environment in the global sense of the term without going into science fiction or hysteria. But we have to take into account the fact that there are technologies that exist and that can make it so that we can't just take it for granted that a piece of information will always or cannot be analyzed in conjecture with information that is circulating in the public domain to produce, deduce, or infer other information.
Thank you. I think it is. We have not previewed these questions with our panel, but you have Professor Trudel, you have hit on one of the other questions that was asked by the participants on how advances in technology will impact the analysis and the weighing that is ongoing. On the issue of evaluating or assessing claims of harm, one of the participants asked or notes that some of the classified information that is within the Commission's mandate, there have been leaks to the media, and certain information, or at least allegations of certain classified information have been are in the public in the form of media stories. Could the panel address how leaked information affects the balancing that the commissioner or a federal court judge, if it came to a Section 38 application, would undertake? So in particular, in some circumstances, would this affect the assessment of the potential injury to national security and the release of documents or part of documents?
So if I was still working in government, my answer would be validating leaked information as true, or asserting that the claims made are true, is in itself harmful, because it then tends to reveal what Canada's national security agencies knew and when, and potentially how. So generally, you will not see national security agencies in Canada and elsewhere validate claims made based on leaked information, because that itself lends credibility. And the other thing I'll say is that the problem with leaked information, especially if it's a leaked document or an assessment, those are potentially assessments made at a moment in time, and they don't necessarily reflect new information learned and that could change an assessment, for example, or of a threat. And so that also has to be taken into account is leaked information, just because it's leaked information doesn't mean it's true information. It may have been believed to be true at one time and is no longer the case. So that needs to be factored in. That said, there have been many a case in the Canadian federal court interrogation methods were used on certain prisoners in Guantanamo, right, was well known, but the United States refused to allow certain information relating to that to be disclosed in a Canadian court because it would be validating things that had not been validated by U.S. government officials. It has to be done, again, on a case-by-case basis, and that's how it has always been done in the federal court. So again, I'll just use the example of information derived from the use of enhanced measures and the fact that enhanced measures were used in certain cases in Guantanamo. That was public, but the balance was, okay, is this ridiculous to withhold from the public as, relevant in this case? When it is so well known, right? It was no longer a question of whether it was true or false. It was very well known and went to the credibility and reliability of certain evidence being put forward. And in that case, the judge said, no, I can't possibly allow this. And so, I don't think, to my mind, any of the leaked information in this case has risen to that level of public truth.
All right. Thank you. If there's no further comments that any of the panelists want to make on that point, I will turn the podium to my colleague to ask some questions about process.
La première question nécessite un...
The first question requires a preamble. We know that in administrative decisions, there are some fundamental rights, but also values that need to be taken into consideration by decision makers in public administration, in the context where some values that are guaranteed by the Charter need to be taken into account by decision makers in the context of disclosure or the decisions to disclose protected elements for national security reasons. How can the Charter, or how should it intervene in the process of disclosing information in question? So in the context of this commission specifically. We probably need to look at the issue or the issues surrounding the information for which these questions are being asked. Once these issues are identified, it will be possible to better perceive the values that are at play. For instance, if we are protecting the identity of a person because their life can be in danger if this information was revealed, well, obviously the right that is being invoked here is the right to safety of the person. So by identifying the issue at stake, we can be in a better position to identify the values that are impacted by this issue, raised by the information that we are questioning whether they should be revealed to the public or not, or to what extent they should be disclosed. So this is how it will become possible to introduce in what we can call the reasoning of the decision-making process of the decision maker, the judge, This will make it possible to introduce some kind of grid where we can say, well, this is the value at stake, and given this value, what needs to be done, and what precautions must we take to ensure that we are aligned with these values and respecting these values. For instance, values related to the freedom of expression. I think it's the same rationale. What kind of harm could be caused to the freedom of expression and the public trust if we unduly restrict the circulation of information? So this is a way to ask the question regarding values on the operational level so that a decision can be made. Because obviously values that are in the Charter of the Fundamental Rights are very abstract, and we have to make them a lot more tangible. And one way to do this, in my opinion, is to properly identify the issues that are impacted with these questions related to information. So we have to see whether they should be made public or not. In the context of this commission, when we look at the mandate, the terms of reference, there are some specific consideration. The commission needs to look at special vulnerabilities of some diaspora groups in Canada. In the context, to follow up on your response, Professor Trudel, in the context where there's some specific vulnerability that need to be studied and analyzed by the Commission, in this context, is the right to equality, or how can the right to equality be one of these issues related to these questions on the vulnerability of some of these diaspora groups? Absolutely. I think taking into account these vulnerabilities to respect the right to equality is to apply the measure of vulnerability. In other words, to truly respect the right to equality and the values, we have to examine the specific vulnerability that can be experienced by some members of some groups, vulnerable groups, or groups that have some specific characteristics with which we can identify vulnerabilities that are more present in these groups compared to other segments of the population. So I think this is, once again, a way to operationalize this right to equality, and because respecting this right means that we have to take into account that not everybody is vulnerable in the same situation, in the same way, to the same events. So this needs to be taken into account if we really want to go beyond the formal right to equality and respect the true value of equality. And I think this is what we need to consider with the concept of fundamental rights in Canada. Also on the same topic, we're talking about different levels since this morning. The issues of confidentiality in relation to national security. For instance, in negotiations between the government and the Commission, and also in judiciary terms, if there is, for instance, so there are some fundamental values. This element of analysis, does it apply only to judiciary or quasi-judiciary decision makers, or is there an element that needs to guide them in the negotiations between the government and the Commission when it comes time to discuss the scope of a privilege or a disclosure related to national security? I would say that the need to take into account and respect values is imposed on everyone, including the judiciary branch and also the executive. So I think these values should be taken into consideration by everyone. Values that underpin our charters. They impact all parties. These are values that concern the rights of all citizens. So everybody who is involved in the decision-making process and also the negotiation process they have to take these values into account. It's not just a private serve of the judge or the commissioner or the commission. This really concerns all the decision makers and all persons who exercise authority.
We have received another question which reads as follows. Do you agree that it would be helpful if this commission disclosed to the participants and the public the guidelines that the commission will use to determine how it will balance the public's interests in disclosure and national security concerns in its work?
So,
well, maybe if I can ask you a follow-up question. Do you think such a framework can exist in a vacuum, or it has to be tied to a specific, in French, enjeu, so a specific concern or on a case-by-case basis?
So to my mind, this might be something that is articulated in the commissioner's findings. Not necessarily in advance. I don't know that it's something that the commissioner could articulate in advance of making these kinds of decisions. Ultimately, the commissioner is going to decide based on her mandate what she believes needs to be made public, and she may ultimately decide injury be damned. And in that case, I suspect that she would articulate the reasons why for that. And presumably, the first time that that's released, whatever it is will be redacted, because there'll be now a battle over that piece of information in the courts. And so I think generally, once a decision has been made about how you're going to write your findings of fact, after you've reviewed all of the information, how you then weighed it, your actual process of weighing that, which I think you will only know once you engage in that exercise, should be articulated to the public in your findings about how you chose what to make public and what not. But I think it would probably lead to I don't know that you could fully articulate your process unless you were to say, I generally plan to apply the Ribbage test and move forward. I don't know how much more granular you could be at the outset.
I mean, I'll caveat this by saying it's not a studied opinion because I've been thinking about it for 2 minutes while Professor West is talking here. But I'll try to do the best I can. And the best I can would be to essentially agree. I think absolutely you have to explain this sort of detail. I see no reason why that wouldn't make the most sense that you would do it in the final report on a case-by-case basis. I guess to add to what Professor West was saying, and again, I'd have to think about it more, but I have as much worry that you would undermine the credibility of the inquiry by coming up with something that was so general so as to apply to any sort of situation or piece of evidence in the final report, that it was easily criticized in the abstract before we ever get to the case-by-case analysis, which is invariably where this is going to play out anyways. So perhaps that's a middle ground answer to your question, which is yes, we should provide sort of guidelines as to how you weight evidence, just like you would, I don't want to make this a court, but just as you would in a court decision, right? I put more weight here. I thought this was corroborated. I thought this was credible. I find this fact this. Here's why. Here's the values that I considered in this case. In this case, it mattered to hear from interveners because they were a particularly affected community and had something, that needed to be said, and to respect their equality, I had to hear from them. In this other case, there's no such person. But again, I think that would be done most obviously in a final report as one explains the findings.
Donc, Madame la Commissaire,
Madam Commissioner, according to our schedule, we have a 20-minute break at 3 p.m. So we will take a 20-minute break. We will be back in 20 minutes.
Recess until 3:20. La séance est en pause jusqu'à 3h20.
Yes, because
The Commission will be resuming momentarily. Order, please. À l'ordre, s'il vous plaît. The sitting for the Foreign Interference Commission is back in session. Cette séance de la Commission sur l'ingérence étrangère a repris.
Welcome back. A specific question for Professor Nesbitt. In your review of past inquiries, we spoke a lot about ARAR since the beginning of the day, but the question is about other inquiries, including also the RR inquiry. What types of cooperation has the government provided? Did they take steps to assist the Commission balance the tension between national security confidentiality and the right to information? And what were those steps?
It was free.
Professor West can jump in.
So I mean, I'm a little limited in my answer to what is provided in the report. So the fundamentals of the report in the RR inquiry talked about the need to that they did some of the pre-work that we've already discussed, but the need to do more of it, and for future inquiries to do more of it. The modern Canadian inquiries have, for the most part, discussed an issue with overclaiming. So I think it has to be on the table that it's a possible concern. It has been something that's been noted in past inquiries. What steps did they take? I think we've covered most of them, which is you try to do as much of the legwork up front as you can. You obviously try to discuss with those involved and help them to understand the importance of providing the information that is necessary, while yourself learning to understand what information just won't be released. And I know perhaps this is a bit of a theme of today, but it often has looked, at least from the outside in reading the reports, like a contextual analysis, right? How you deal with that depends on what the claim is, whether it's an overclaim, whether it's a legitimate claim that's being balanced with a real imperative of the inquiry to make certain information public, understanding that there are also reasons not to make public. There, of course, just to be thorough, I mean, there are other options here. You can take it to federal court and have a Section 38 Canada Evidence Act dispute. That's, as Professor West has already discussed, it's neither efficient nor effective. Particularly given the timelines of this. I suppose it could happen. Maybe it will have to happen. I no idea and don't want to speculate on that. But the timelines on that generally don't allow for the completion of reports in 3 months from now, or even 10 or 11 months from now. So that would certainly be, as the RR inquiry said, it's an option that's on the table. It should be the last option. And to reiterate, I think the more important point is that serves no one well. None of the parties, no one involved, the government, nor the parties, nor the Commission are served well by that approach. So a collaborative approach that works ahead of time to negotiate a solution is usually the best one.
I'm going to just take examples from other types of bodies that are in this game. So mentioned in CSIRA and in NSI COP, both have taken steps to articulate where they felt that government agencies were not being forthcoming or overclaiming in their reporting. And they also praise those agencies who do a good job in responding to requests for information. So that's something else. Institutional reputation is important for these agencies because institutional trust is crucial to their work. So if the Commission finds that certain agencies are being deliberately obtrusive, even if you can't get to a point where you get that compromise, making that clear in the report is something other agencies have done, and might be something that would make them reconsider their position, just like praising those agencies who do a good job in that regard would help bolster confidence in those institutions.
So since the beginning of the panel today, we have discussed the importance of cooperation, as Professor Nesbitt has just mentioned. But what is your opinion of the importance of adversarial debate on national security confidentiality issues in the context of a public inquiry. So at all levels, the negotiation and also, well, we'll stick to that. So in the negotiation context, the role of an adversary to the government in the context of an inquiry. What is your opinion about this relationship between parties?
Can I clarify what, well, maybe you don't know, what is meant by the question by an adversarial relationship?
Well, this is not my question, so I wouldn't know, but in the context of the discussion that we had this morning, so the role of Commission Counsel in negotiating those claims with the government. We also mentioned earlier the notion of a special advocate in certain national security settings. So this element of having an adversary in front of the government. So do you think that this is a necessity in the context of an inquiry or this specific inquiry?
Yes. And that's why it had to be added on in the Arar case through special advocate that were designed specifically to take that role. Their job wasn't really to bring out the facts. Their job was to challenge claims of national security confidentiality. And so, you know, I'm heartened to see that there are several counsel in the commission that are well placed, and I can't think of people more experienced than to do that job here. I'm sure we're appointed for that very reason, because they have history, credibility, experience, taking it to the government on their claims of national security confidentiality, because it is absolutely crucial that you have people who are capable and competent to engage in that process.
And I don't want to interrupt you, Professor Nizba. I think you misspoke about the RR, and you mentioned special advocate.
Sorry, yeah, I meant to say Amici Curie, sorry,
Okay.
Thank you.
Yeah, it's a more general answer, but maybe it speaks to both this and your previous question. And that is, in certain circumstances, it's been clear that the approach has to be somewhat adversarial in a general sense, which is to say, the word I used repeatedly in the talk this morning was you have to push or challenge. That is quoted multiple times, or some version of that is said multiple times in the Arar report, obviously as an indication to future inquiries that sometimes it will have to be adversarial in the sense of challenging to release more information, challenging the justifications perhaps. That may be to release the information, that may be just challenging them to ensure the commissioner is satisfied that the information should be protected. But again, we're not just referring to the Arar inquiry there. That was, as I believe I quoted Professor Kent Roach. Kent Roach, of course, was part of the Air India inquiry and is drawing lessons from that as well. I spoke this morning of a public published article by a prosecutor with a long history of dealing with national security litigation in the criminal context. And again, he said the same thing sometimes. He put it as you have to be adversarial, but he sort of said, but you start the process early and you start that negotiation. And to some extent, I read into that. And sometimes that means that sort of process of pushing. So I think they're absolutely, as Professor West was saying, absolutely it has to be adversarial sometimes. That's the nature of it. It's why we have commission counsel to some degree. But it's also, I think just based on past practice, my previous answer was, well, it's going to be contextual. How do you convince someone of something? Well, it depends on who the person is and what the context is and what you want to convince them of. But what is clear is, however you take that adversarial approach, whether that's with a carrot or a stick, sometimes that has to happen in the context, and the history has suggested it may, if history is an indication, happen here as well.
Thank you.
At the risk of misreading the question that we were submitted, I think it may have to do the use of adversarial may be in comparison to inquisitorial and have to do with sort of the role of commission counsel. And you may not be the panel to ask, or you may well be, given your experience in Professor Nesbitt in studying commissions of inquiry. But the commission counsel role, is that one that is purely inquisitorial, or can commission counsel take on, for example, by engaging not just in examination in chief, but asking cross-examination type questions? Is that a method that has been used in prior inquiries? Is it available? Is there, does the role of commission counsel permit a kind of taking a challenging posture or position in a commission of inquiry?
That's for you.
Unless someone disagrees with me, I see no reason why not. And as I said, I expect it might have to happen. I mean, the commission's report is going to depend on the extent to which it is impartial and independent. As was discussed yesterday, it is an impartial and independent body. That means that the commission counsel might have to play the role of being a little less inquisitorial and a little more vigilant in trying to get the information that's in the interest of the commission to receive.
And that would be especially true in in-camera proceedings where you do not have party counsel who can ask or cross-examine witnesses.
Thank you. Following up on the discussion we had before the break about charter values, a question was posed. Would you agree that giving targeted individuals and communities the ability to take precautionary measures in the face of imminent threats of foreign interference or transnational repression is an aspect of the public interest in disclosure, or something that weighs in favor of disclosure? How do you feel this should be factored in to be struck as the commission conducts its work? I pose the question to any of the three of you that wish to respond.
So especially in the second half of the commission's mandate, I do think that there is a role not just for national security agencies, but the commission in making sure the public understands broadly how foreign states seek to influence the public or a subset of the Canadian population in order to build resilience. I think that's a part of the job our security agencies are taking more and more of, but also, the public education aspect of it, of this is the type of threats Canadians and Canadian communities are facing from foreign actors, and this is the impact it can have on our democratic institutions, I think are appropriate findings for the commission to be making, and definitely part of that public interest. But again, I think you can make findings of that sort without revealing how our security agencies have come to know the details of that. I think it'll be very important to hear from those communities in a way that they feel safe so that they can explain that to the commission, and the commission can, on behalf of those communities, explain it to the Canadian public.
Thank you. This question begins, we understand the need for confidentiality or classification to protect national security interests. The question for the panel is whether you would acknowledge, or can you speak to whether there are national security interests that are served by the disclosure of information, even sensitive information, in the sense that the questioner suggests that could promote awareness or serve to insulate, I should say, the public from the impact of foreign interference. Professor West, I see you nodding your head, so.
Well, I think that goes to the point I just made, but also, I mean, we're seeing that very clearly be articulated by the Canadian Security Intelligence Service right now. They're in the midst of doing public consultations saying, we want the ability to share more information that we've collected in our investigations with provincial governments, universities, et cetera, in order to help them build their own resilience. I think the same thing would apply to diaspora communities as well. And so we see that kind of work being done routinely when it comes to cyber threats and cybersecurity threats. We have a whole agency now basically dedicated to that in the Cyber Canada Cyber Center that's designed to articulate to the public what these threats are, and they've done that in the case of democratic interference. And so I do think that there is an important role of informing the public and potentially declassifying information to build resilience. And we've actually seen that not just in the case of foreign interference, but with other threats. We've seen other intelligence agencies, including the Department of National Defense, release or declassify information to counter disinformation coming from other states, to help Canadians become more resilient and understand, to actually get into the fight of not leave a vacuum of information, but actually to help fill the void and enter into the debate of public ideas by declassifying certain information. So I think there absolutely is a need, and I think a growing recognition of the need to share information that intelligence agencies know in order to build public resilience, not just with foreign interference, but a variety of national security threats.
There is an advantage, there is even a need for better knowledge on behalf of the whole public regarding possible strategies or activities of interference. For example, in electoral processes, interference can come from all sorts of sources, and if we take the example of false information or misinformation, which can go viral, which can be targeted, so regular citizens are targeted, and they are likely to be the first targets of such interferences. So improving the general knowledge of the public of the risks specific to the fact that information is circulated very rapidly and can land very quickly in our cell phones or in all the tools that we use in our daily lives. That's certainly an issue which requires much more transparency. So I totally agree with the person who was asking this question. I think that there is a requirement for sharing all situations where foreign interference can be determined, particularly when using the various technologies which are used on a daily basis today.
Transparency Advisory Group, which is an independent advisory body that provides advice to the Minister of Public Safety on implementing Canada's transparency goals, has written about this quite extensively. And they have published 3 reports, and one of those reports dramatically highlights, all of the positives that come to national security from transparency. So it might be a reference for the Commissioner.
Yeah, I was actually going to sort of point to the same thing. And in part I was going to, no, that's great. And I was going to point to it because I was going to tie it to a quote I had earlier from the Aurora inquiry, which is that overclaiming, and I quote, also promotes public suspicion and cynicism about legitimate claims by the government of national security confidentiality, end quote. And so the flip side of what was just said is that if you have a situation of overclaiming, if you're not sharing the information, if the public isn't understanding what's happening, you have a lack of trust. And a lack of trust in our institutions eventually will lead to the failure of the institutions. And so at a very fundamental level, some form of transparency, which allows for, as I was discussing this morning, accountability, is fundamental to upholding our national security apparatus as a whole. And so absolutely there are benefits, right? The corollary of that is if a lack of trust undermines the potential, the activities, the likely powers in the long run of our national security agencies, then public trust in those institutions will garner more support for them and will allow them to act in our interest better.
Okay, I just want to add one last point on that, in that lack of trust in our institutions is probably at its greatest in a number of diaspora communities and ethnic minority groups across Canada because of lack of accountability when there's been wrongs to those communities or over surveillance, et cetera. And so given the nature of the question at hand, I think it's additionally important in this context.
Thank you. Just a few more questions specifically about some of the intricacies of Section 38.
Oh boy.
Professor West, one of the questions we receive submits that the procedural safeguards contained within the Canada Evidence Act were an important consideration in favor of constitutionality when different provisions of that act have been assessed by the courts, and specifically the regime provided by Section 38. Are these safeguards, these sort of constitutionally saving safeguards, are they applicable in the context of a commission of inquiry? And the questioner asks, for example, or poses, for example, whether risks of the infringement of certain charter values or protections that were discussed earlier in our presentations, can these be our remedies such as a stay of a proceedings or a stay of indictment or limiting the amount of information provided in relation to an indictment? Those don't seem to have a specific sort of applicability in this context. Can you provide any insight on?
So there's two things. One, a large part of that is in the context of criminal proceedings, where the accused has a right under Section 7 to all of the relevant information before them at trial. Those constitutional premise or the procedural safeguards, right, do matter to an extent in civil cases or judicial review, but not quite to the same extent. So some of those safeguards, like a stay of proceedings, for example, or the ability to deny the admission of certain evidence, are more applicable in that context, and I don't really think transfer well to this context. But the other thing I'll say is no, because at the end of the day, in this case, the government still gets to decide what is disclosed or not, right? That was made very clear in their institutional report. You know, at the end of the day, the government has control over what information that is privileged under by national security claims can or cannot be released, not the commissioner. The commissioner will argue and, or through her counsel, argue for what you want to be disclosed, but at the end of the day, the decision rests with the government and ultimately the Attorney General. And if there can't be agreement on that, then you go to the court, and that's when those safeguards kick in.
And turning then to follow that, where Section 38 is engaged, would you agree that it is important for the public to be aware that the Commission does not agree with certain national security claims by the government? And in that context, in your view, would it be important for the Attorney General to authorize disclosure of the very fact that a notice under Section 38.02 of the Canada Evidence Act has been given by the Commission?
Absolutely.
That looks like agreement across the board, no differing opinions on that point. Thank you. I'll just take a moment and consult with my my colleague on our remaining questions for you. Just one moment. One further question. And my trouble in reading this question is not with the question that was posed, but with my my increasingly problematic eyesight. Before the lunch break, Commission Counsel, I suppose that's me, asked the panel about the balance between national security confidentiality and the public interest in fair and free elections and democratic processes. What are the thoughts of the panel on the balance between the interest of parliamentarians in being aware of infringements of their parliamentary privileges, which protect their ability to fulfill their duties free from obstruction, intimidation, or interference, and national security confidentiality? Is anyone able to address that question?
So I'll start because I assigned this as a case study to my ethics class last week, essentially. And really, you know, parliamentarians who have a job to maintain accountability over the government and who have privileges in order to do that, how much do they need to know? I would say in this case, we know that there's allegations that they need to know specifically because threats have to do with them versus the interest in national security and not disclosing certain information potentially about those threats. To me, that's really a question for the national security agencies who have the full picture and understand the level of threat. In an ideal world, I think anyone who faces a personal threat or a threat to their ability to uphold their duties in a democratic institution should have as much information as possible. But it would be very case dependent, and I don't think anybody could make that decision other than the agencies holding all of those cards. But I think that the agencies with that information would need to take into account a parliamentarian's role, very important role in democracy when weighing those the potential injury of revealing more information to them. My students really should have been watching that.
Beyond the exam. I'll just take one more moment. Commissioner, those are all the questions that we had for our panel this afternoon.
Thank you. Thank you to all of you. Merci beaucoup à vous tous.
Thank you very much to all of you. It was very useful for me, so I would like to thank you.
Resume tomorrow at
10 a.m.
10 a.m. Thank you.
This sitting of the Foreign Interference Commission has adjourned until 10 a.m. tomorrow. Cette séance de la Commission des Affaires étrangères est levée jusqu'à 10 heures demain.